Hey, good afternoon, everyone. Mr. Lewis, what do you have?
Judge, on page 10, I have James McFadden. I see he's on your
Give
male
us a moment,
magistrate
Judge.
list.
Got to make room.
In the meantime, may I see Mr. Ortiz, please? Mr. Gibson's here on Ortiz. Mr. Gibson, you ready to go?
Come on up. It's going to take you a minute.
Mr. Gibson, your client is charged with aggravated battery, bodily harm, domestic violence, count 2 and 3, tampering with evidence. Now, I know that your client went to see another judge yesterday on that trafficking matter. What happened with that?
It was, the court did not take any act on it. That was Judge Bober, because the matter had been transferred to Judge Levinson. I've notified both divisions of this arrest, Your Honor, and I've asked for a nominal bond to be set because, quite frankly, he's in compliance with his bond conditions in the trafficking case. It's been out for years without any kind of hiccup. And once you peel back the onion on these allegations, I'm convinced it's one grave misunderstanding between two adult individuals.
Okay. He's out on a trafficking case, picks up a felony ag bat, tampering with evidence. Do you have any issue about probable cause today?
Your Honor, if the court's interested in the Parker issue, the court wants to entertain the Parker issue. I have not put an investigator on it. My understanding was that both parties were exceedingly intoxicated, and there was mutual combat. I do believe that much of what was said about the broomstick was revisionism by the police officer, who, quite frankly, I don't have a problem with the cop working the case out after the fact on scene. But I do believe that both parties, how can I put this, had some bodily injury. Who started it? Who knows? But both parties were exceedingly inebriated. And I understand that the alleged victim is not in agreement with these proceedings, if I understand it correctly.
I don't know. Let me ask. I'm going to put no contact. Yes. Okay. Well, can you tell me any of his financial background so I can set an appropriate bond?
Judge, he's a barber, self-employed. His wife is here, family member. He's been out on bond almost 4 years on the trafficking case. Has not had a blemish.
And his wife is Joe?
Jasmika Ortiz, she's present. She'd be willing to act as a custodian for the bond. I don't believe he's a danger to himself and the community.
Your name is what, ma'am? You're married to him? But you don't live together, right? Well, it says right here he's living together over 7 years with a woman named Joanna Pereira.
That's the first misstatement of fact in that offense incident report. He resides with his wife.
It says he has two children with this person.
Well, Judge, that is true. They do have children together, but his wife is present here, and that's who he lives with.
Okay, well, just trying to figure out where we are on this. Okay, so, all right. So he's a barber, and does he own his own home that you know of?
Wait a second.
Ben, you want to come up here real quick? Just put your personal birth.
You're here on a trip.
Thank you, ma'am.
We're going to try to get that resolved for you today.
Ma'am, raise your right hand. Do you swear or affirm to tell the truth, whole truth, and nothing but the truth? Put your hand
Greg?
out. Tell me your name.
My name is Jasmika Mejia Ortiz.
Nice to meet you, ma'am. Are you married to Jozu?
Yes.
Do you have children with him?
2.
How old are they?
My oldest son is 10 and the youngest is 8.
Okay, so your husband lives with you, correct?
Yes.
Okay.
We
And,
had-
go ahead.
Yeah, we had a little separation in between. That's when he had the other kids.
Okay. And he's a barber?
Yes.
Do you own your own home?
No, we used to, but we lost.
I understand. Do you have joint bank accounts?
Yes.
Do you have money, very much money in those accounts?
No.
No? Okay. Who would pay to bond him out of jail today? Would it be you?
Actually, all the family's going to chip in. He's a very, without him, we can't do nothing right now.
Okay, and does he help support the family members?
Yes.
Okay. Okay. So, allegedly hit a woman with a broomstick.
My understanding is when the truth comes to light, that's an actual opposite rendition of what actually happened.
Yeah.
Just make sure I'm here.
Since he struck with both fists, causing her to lose consciousness. He's got a prior trafficking, so was it withheld on it?
He's never been convicted.
On what, the trafficking?
It's open.
It's open.
Yeah, we know that.
Is it open?
Yes, it's open,
Oh,
Your
it's
Honor.
not probation.
Nothing, no, it's still open.
He's on bond.
Well, it
He's
was
out
a
on bond.
2011 case, so that's why.
He's on bond,
That's
Judge.
why I said it twice, Your Honor.
Excuse me?
He's out on bond.
Oh, I'm sorry.
That's why I said 4 years, out on bond, not a hiccup, not a problem, no pretrial issues.
Did it go up on appeal or something?
No, it hasn't been tried. My lawyer team had it. I substituted it about 3 weeks ago. Judge Bolger then sent it to trial division in front of Levinson. He then resent it for November. In the meantime,
Was there a court date yesterday? I thought it was reset yesterday. It
but
was,
Judge Bolger didn't have jurisdiction, so
so nothing really happened?
nothing happened.
So nothing was in between?
That is correct.
So there was no decision on if he was out on bond or not? Probably didn't know he was out on bond then.
Judge, again, for the record, I advised both Judge Bolger and Judge Levinson personally regarding the bona fides of this allegation. I thought it was my duty as an officer of the court. In both instances, except in one instance, Judge Bolger said he could take no activity. On the second instance, I advised Judge Levinson and advised him of these proceedings.
Does he have any other criminal record besides the trafficking that's open?
I'm looking right now.
Never even arrested.
There's something else.
Sir, can you try to call the alleged victim again? Can you give that a shot? I have 2 telephone numbers, do you?
I just have one, 7865.
Whoa, step.
I know.
Okay. Are you injured? Do you have any injuries?
Are you injured?
Well, the allegation is you were hit over the head with the broomstick and punched to the point you went unconscious. Go ahead.
I never said I was hit with a broomstick. I did have a black eye, but it went away, and it was, we were both arguing. Before that, of course, we were drinking. So, you know, the way that things happened is a little hazy.
Right.
There was some pushing and shoving on both ends, and like, to tell you the truth, I can't tell you exactly what happened. I know I was pushed to the couch and had a corner. I could have bumped my head there and hit my face.
Who called the police? Do you know?
My aunt, she was not in the house at the moment when they called, when she called me.
Have you had to see a doctor?
I'm sorry?
Have you had to go to the doctor or go see a
No.
medical person? Let me ask you, do you know him to carry any guns or weapons with him?
No, no.
Has there been violence in the past?
Sorry?
Has there been violence in the past between the two of you?
There was an incident 3 years ago.
Tell me what happened.
We were arguing, and again, the neighbors called the cops.
Mm-hmm. Were you injured?
Yes.
What happened?
He hit me in the face.
Okay, was there drinking then?
No,
No? Okay.
not on my end.
Let me ask you, if I release him from custody, do you think he's gonna do anything to you, harm you again, harm your kids?
No. No. He wouldn't harm me, and the kids definitely not.
Well, okay. All right, ma'am. I appreciate your time, and I'm going to go ahead and. How old are the kids, by the way?
My daughter's 5, and the boy is 3, turns 4 next month.
How? And let me ask you, does he help financially support you and the children?
Completely.
Completely. All right. Okay, ma'am. Thank you for your time. Okay. So, here where we are. It's kind of a mixed bag. On one hand, she says she doesn't want to go forward on it, or not go forward, but it seems that I got the impression that she's not highly motivated to prosecute the case. And it does seem she downplayed what happened, what allegedly happened. However, by the same token, she did say that there's been a prior incident and there's some violence in the past, which on one hand, that makes my antenna go up, that there's ongoing domestic violence in the relationship. So it's kind of a tough, tough sometimes in the domestic violence cases to sort things out. But do you have any comment about bond today, Mr.?
I do, Your Honor. I would submit nominal. And obviously, a component of any bond would be to stay away from her until these charges are resolved. I don't know if the court wants to say no contact, no harmful contact. I'll leave that to the judgment of the court. But I've always believed in the safest road. But I think that what she said essentially corroborated much of what I said to you by proffer. This is the temperature of the teapot. Both parties are drinking. If this was originated by a cop regarding a number of things that are not provable, I think that, quite frankly, when the name is punched in and they see trafficking, things happen. But this earlier allegation of domestic violence, I don't believe it resulted in any arrest.
No, I don't think it did. But when it comes to bond, the court has to be able to consider a wide range of things, and the court believes that the defendant's potential or the alleged victim's potential risk to harm, future harm, while the defendant's on bond, the court believes is a valid consideration. I'm going to set the defendant's bond on count 1 at $7,500. Count 2 and 3 will be $500 per count. His total bond today is going to be $8,500. I'm going to leave the revocation of bond up to the trial judge. All right.
Thank you very much.
Judge, is there a no contact order?
Oh yeah, I'm going to do that. So I'm going to order, for the time being at least, you not to have any contact directly or indirectly with Joanna Carrero. Do not call her, do not text her, do not email her. Stay 500 feet from her at all times. That is where she lives, works, goes to school. Anywhere in between, you're not allowed to possess guns, weapons, firearms, or ammunition while you're on release. Now, sir, I'll allow indirect contact. You can go through a third party to have contact with Ms. Carrero. You have children with her. You're going to have to pass on money or funds, check on the welfare of the children. I'll allow you to do that, but don't do it directly. Go through your lawyer, go through a family member to get that done, all right?
Thank you, Judge.
Judge?
Anything else?
Judge?
Thank you. All right.
Judge?
To be clear, I'm not considering revocation of bond. I'm just, so we're clear, I'm leaving it up to the trial judge, a de novo review. I'm not, so nobody says I considered it.
I understand.
Okay?
I understand. I do.
Got it.
Thank you, Judge.
Okay.
Appreciate the court's time.
You're done. Okay. Mr. McFadden is present, Judge.
Judge, good afternoon. James Lewis on behalf of James McFadden.
All right. All right, what's the, Who do you have there, Mr.?
Judge, I have James McFadden on page 10. James Eric McFadden, he's the gentleman here in the wheelchair.
James McFadden, hey, sir. So you're here for an attempted murder, and frankly, I haven't read this in about a week. So let me just look here real quick, see if I remember this. Okay, so the defendant is charged with attempted murder, and it says here that there were several other security witnesses attempted to confront the subject as he was leaving the venue with alcohol. A friend of the confronted subject, identified as McFadden, became angry, got physical with the victim, who was the security officer. Defendant pushed the victim and said, "I'll get you," before walking off. Minutes later, McFadden returned, approached the victim from behind, pointed a black handgun at the back of the victim's head and fired 3 times, striking the victim in the neck and face. McFadden immediately fled on foot. Witnesses directed officers to the fleeing McFadden, and foot pursuit ensued. The defendant was shot in the leg by FLPD. He was taken into custody. A .25 caliber handgun was recovered in his possession, and 3 .25 caliber casings were collected at the scene where the victim was shot. Now, this is a first-degree felony, punishable up to life in prison. Are you seeking to hold the defendant without bond statement?
Yes, Judge.
Okay, at this time, there needs to be a showing a proof evident presumption great. The court's reviewed a very brief affidavit.
Judge, I can tell you that I've been in touch with the Fort Lauderdale sergeant who's been investigating this case. There is great question in who the actual shooter in this incident was. There have been allegations that there was a second individual that, upon shooting the victim, handed the firearm to my client, who allegedly took off running in a different direction. So I know from talking to Fort Lauderdale police it is an active investigation. I do not believe proof evident is presumption great. If the court is of a mind, then I'd ask for a full-blown evidentiary hearing on the issue scheduled for next week, because again, I don't think there's anywhere close to somebody present here.
Well, here's where the court's going to come down on this. The court does note there are facts which not only allegedly show motive. He said, "I'm going to give you." There was some altercation. He allegedly said, "I'm going to give you." Several other witnesses, security personnel on scene. They say the defendant shot 3 times. They found 3 casings, .25 caliber casings, and when the defendant was fleeing, he was shot by FLPD, and when they found him, he had the .25 caliber handgun on his person. So we have allegedly a motive. When he said, "I'll give you," multiple witnesses on the scene put him there, and he's running away with the same type of gun that they found the casings for. So,
Judge, I tell you, I guess I'd ask you to take into consideration that he has been in the hospital for a week. He was shot twice in the back of the legs, I might add, by the Fort Lauderdale Police Department. He is taking all kinds of medication, in need of physical therapy. You can't really see there, but his leg, really from his thigh all the way down, is bandaged up and requires constant treatment. He has lived in South Florida his entire life. Just proffer some other things. And of course his mom and them, they didn't know that we were going to have a hearing today, but I can tell you that he went to Plantation High School, where he played football. He went to college at Norwich University in Vermont, where he played football. He has 1 child here, 9 months old. He is employed in a restoration business, something called Weston Waterproofing. If released, he would reside with his mother, Kathy Aaron, at 6211 Northwest 18th Street, Sunrise, Florida. And again, Judge, I wish that we had at least an officer or some witness statements here. My understanding, again, in speaking with Sergeant Steve Novak, who's in charge of this case with the city of Fort Lauderdale, is that there really is great question as to who was the actual shooter in this case. Apparently there have been conflictory statements as to who the actual shooter was. So I know that's not before the court, you don't have that information, but I'm just suggesting that before you find proof evident presumption great, that it would be appropriate that we at least hear from the homicide investigator that's has the case.
Court notes your argument, but the court will find proof evident presumption great today. The defendant will be held without bond. It's based on the facts of the case. The court also relies on the Preston case. The court also relies on the Keel case of the 4th ECA. And the court believes it has met proof evident presumption great based on the affidavit. The defendant will be held over for an Arthur hearing. That will be set, I believe, by the defense.
Before Judge Rothschild, yes, Judge.
Thank you very much.
Thank you, Judge.
Have a nice day. Okay. Okay, everyone, my name's John Hurley. I'm your judge this afternoon. We're in first appearance court. You have the right to remain silent. If you give up that right, whatever you say can and will be used against you. If you have a private attorney, let me know who that is. We'll contact your attorney and let them know that you're in court. That's you, Jimmy Lilly.
Jimmy Lilly? He's helping that gentleman out with the wheelchair, Judge. Judge, if I could call one out of turn.
Well, here comes Jimmy Lilly right now.
Here's Mr. Lilly.
Sir, battery, domestic violence, resisting arrest, court finds probable cause. Do we have any do we have a criminal record on this defendant?
Battery in 2005 that was withheld.
Got it. Anything else?
No, Your Honor.
Go ahead, Mr. Miller.
Judge, Mr. Lilly has been a resident of South Florida since 1988. He has strong family ties here, some money in the bank, no land or real estate. He works in a restoration business. He's been doing that for about a year and a half. He does have a place to stay separate from the alleged victim. He's expecting the alleged victim to bond him out, Judge, and I just would point out to the court that the alleged victim in this case is reluctant to cooperate with the state attorney in the prosecution of this case. And I would ask the court to set the bond accordingly.
Okay. Do we have...
There was contact. She is not concerned with her safety.
Not concerned with her safety. This was allegedly throwing a shoe, and the shoe struck her in the chest. Right. So based on the facts of the case, your criminal record, I'm going to set your bond on count 1 at $1,000. I'm going to set count 2 ROR, and I'm going to order that you have no direct contact with the alleged victim, and her name is Star Fooch. No contact with Star Fooch directly or indirectly. Stay 500 feet from her at all times. That's where she lives, works, goes to school, anywhere in between. You're not allowed to possess guns, firearms, or ammunition while you're out. I'll allow indirect contact. Can you go through a third party to have contact with Ms. Fooch regarding the finances and the family, but that's third party contact only. Thank you.
Thank you, Judge.
Sir,
if I could call one out of turn.
Go ahead.
It is Mr. Down the middle, out the door. Michael Reese is on page 8 of your docket. It's a reset from this morning. Keith Seltzer is his attorney and would like to appear by phone. I just got
Judge,
off the phone with him.
I have the phone number for you.
What's the man's name?
Reese.
No.
Reese, Judge.
Do you have his number?
Yes. 954
Got it.
294.
Cell number, Paz.
294. Mr. Seltzer, Judge Hurley, how you doing?
Your Honor, thank you very much for accommodating me and conducting these proceedings by phone. I'm doing well.
Good. We have a man named Michael Reese who's been charged with false imprisonment. And I've read the affidavit. Do you have any objection about probable cause today, sir?
No,
Let me ask, was there any contact with the alleged victim?
was that a domestic one?
Yeah, no, I'm talking to somebody in court.
Oh, sorry.
Did you have, it was from this morning.
I wasn't, no.
No, okay.
Dating violence.
Does this defendant have a criminal record that we know about?
I represented him in a felony possession of cannabis, 7 or 8 years ago, for which he did a short period of probation that was early terminated.
Okay.
Prior to that, Your Honor, there were charges
Got it. Okay. Anything else? No? Okay, Mr. Apparently he has a prior battery from the 80s, uttering a bad check, and your felony cannabis. Is there anything you want to say on behalf of this defendant regarding?
I was aware of the complainant applying for a restraining order. The hearing was to be held on August 31st. Therese went to that hearing. She did not appear at that hearing. So the restraining order was dropped by Judge Kaplan's office.
This is,
At that proceeding.
case has already been
We
filed.
never heard anything else about this. This is, and I don't want to besmirch the complainant without her having an opportunity to respond, but this woman has quite a few issues that I think will give rise to a significant defense in the case, as well as an establishment that the facts are not actually as alleged. I would ask that the court set a bond on the false imprisonment charge somewhere in the amount of $3,500 and another $1,500 on the battery charge for a total of $5,000 now.
We don't have a battery. This is false imprisonment only. Is it?
Actually, Judge, it's, the information's been filed,
Right.
false imprisonment and battery.
Misdemeanor battery?
Yes.
Your Honor, remember this morning, that was
Got it.
we set it for after.
So I'm filling in battery on count 2. Okay, so do you have any comment about Bond? Allegedly was whipped his girlfriend with a towel and told her to sit in a chair and wouldn't let her get out of the chair for 15 minutes.
And
Go ahead.
there is evidence that you will establish that the only reason there would have been any communication with her was she was extremely intoxicated, and Mr. Reese was trying to prevent her from killing herself or anybody else by driving. She did not ever prevent her from leaving the home. She could have easily left the home as long as she wasn't going to drive.
Right.
Well, Judge, the PC also says while Reese was hitting the victim, he said, "You're lucky it's not a bat." So state would argue that the bond should be higher than $5,000.
Okay. I'm going to set his bond on count 1. I'm going to set the bond at $7,500. Count 2 at $2,500. His total bond today is going to be $10,000. It's based on the level of violence the court's concerned, the safety of the alleged victim, and noting that he does have a criminal record also. Court's going to order no contact with Elise Pedal or Pedal. No contact with her. Don't call her. Don't text her. Don't email her. Stay 500 feet from her at all times. You're not allowed to possess any guns, any firearms, any weapons while you're on release. Thank you very much,
Thank you, Judge.
Mr. Seltzer. Take care. Thank you.
Thank you, Judge.
Ma'am, may I help you? Which case are you here on? McFadden? Wait, you already did McFadden? Stand right there, ma'am. Yeah, just set your purse right on the. Did I talk to you on the phone?
No, sir.
What
The one that was in the wheelchair.
Yeah, you found proof evident presumption, great.
Yeah, okay. Raise your right hand, ma'am. Do you swear or affirm to tell the truth, all truth, and nothing but the truth?
No.
Put your hand out. Tell me your name.
Jonquetta Johnson.
Okay, Ms. Johnson, you're here on the McFadden case, correct?
Correct.
We handled that like probably 5 minutes ago. That's it. If I would have known you were coming, I would have waited, but I didn't know.
I was outside sitting, waiting.
Oh no, I'm sorry about that. How do you know Mr. McFadden?
Boyfriend.
Boyfriend? Okay. Do you know Mr. Lewis, his attorney?
Yes.
His office is right across the street, I believe still. think his office is right across the street. You may want to go over there and catch him and talk to him about this case.
Okay.
Okay? All right, ma'am.
Okay.
Thank you. Sorry we didn't get you in here, okay? Okay. Okay, may I see John Dosel?
That's a medical reset, Judge.
Okay. Okay. We're going to, there you go. We'll reset it for Friday PM. Is he Mr. Joseph?
North Broward.
Yeah, Mr. Joseph.
While we're waiting on Ms. Joseph, this court released her to the supervision on pretrial on September 9, 2015, in a case of possession of PVP, case number 15-11122.
You just north, Your Honor.
We're going to ask that based on the court's finding of probable cause in this case, that her pretrial status be revoked at this time. I'm sorry.
Ma'am, today your bond's gonna be $100 on the theft. I'm gonna revoke your pretrial release on the flacket charge 15-11132 CF10. You're gonna be held without bond. Ma'am, would you like me to put you in the drug program while you're in jail?
Tell me. No, well, I'm actually signed up for the starting place.
Well, that's off the table right now. You're gonna stay in jail for at least the short term. While you're in jail, would you like me to put you in the drug program?
Well, how long is the short term?
Well, you can be. I would imagine at least 30 days you'll be in the jail. So, what would you like to do? Okay, thank you, ma'am.
No, so no bond?
No, ma'am. You're gonna be held without bond. Thank you. How about Aretha Jester?
Your Honor, I got an email from Marge. Her bond was posted.
Bonded.
Okay, Miss Yolanda Rush.
Bonded.
Okay, may I see Jeffrey Alexandre, Ronald Davis? Marius-
Bonded. Mr. Davis?
Alexandre bonded?
Yes, Judge. This is
Got it.
Mr. Davis.
David? Davis bonded? Marius-
So Davis is standing here.
Oh, Davis is there, sorry. What about Santana? Did Santana bond? No? Got it.
Santana bonded.
Got it. Okay, Ronald Davis, you're here for lodging on the city-owned property. Why don't you wait a minute and I'll call you in. Have a seat. We'll call you back, all right? Thank you.
Don't worry about it.
I could do the Extanis case if you would like.
Okay, just give me a quick moment. Okay, let me just think about this again.
They said Russian justice bonded, right?
Okay, so we put that over there. Okay, Parrish Pratt,
Okay, sit down.
sorry about that.
Pratt, come on up.
Parrish Pratt violating probation on a felony, that's no bond. Charles Newton, Andres.
Judge, Mr.
Go ahead, sir.
Mr. Newton is going to be hiring Glenn Rotterman to
Okay.
represent him on this case.
Just give me a quick moment, I'm gonna contact Mr. Rotterman. Tell him that he's got a client.
Yeah.
We could have told him when we saw
I know.
him.
Okay, Mr. Newton, just have a seat. I contacted your attorney. I sent him a text. We'll see if he responds, all right? Now, see, Andres Escuerdo, let me just say, if I ever send an attorney a text, it's just scheduling. I don't get into the nuts and bolts. I just say, you have a case in first appearance, do you want to come over? So I think the rules allow a judge just to convey scheduling, but not the heart of the matter. Hold on one moment. Now, Andres Escudero Herrera.
Main jail judge.
Sir, possession of PVP, drug paraphernalia, attaching a plate not assigned. Court finds probable cause. Do we have any criminal record on this gentleman?
Possession,
No, no criminal record. No, are you sure? He's got a whole bunch of aliases.
you see anything on him?
Andres Escudo Herrera.
Yeah, he has a prior.
Okay.
I see an aggravated fleeing and eluded law enforcement officer in 2009.
Yeah, I have a couple.
2003, he was arrested for domestic violence battery. That was dropped. During the pendency of that case, he failed to appear on 2 separate occasions. 2009, resisting without violence adjudication.
Okay,
He was arrested.
I think that's good. Mr. Miller, anything you want to say on behalf of this defendant?
Judge, Mr. Escudero is a 19-year resident of South Florida with strong family ties. No money in the bank or real estate. He does remodeling. He's been doing that since he's been old enough to hold a hammer. Nobody to help bond him out, Judge. We're hoping for free trial with a drug rehab component.
Okay. Just not very good, I think.
That's okay, weren't you remodeling anyways?
I'm done. Still.
Sir, I'll release you to pretrial release. You have to be there tomorrow between 8 and noon time in the morning. You're going to have a drug and alcohol evaluation, sir. You're going to be drug tested every week. If you fail a drug test with anything, you'll go back into custody, all right? Thank you.
Thank you, Judge.
Ronald Davis.
Okay.
And the 5-year probation was not.
Go down there. Mr. Davis, right there, that microphone is live.
Mr. Davis, you're here for sleeping on city property, I think down in Hollywood. Are you working at this time, sir?
Not at the time.
Do you have any money in the bank?
I haven't checked.
Okay. Do you think you have much money in the bank?
Yeah, I think it's just $100. Like I said, I just got back into Florida.
Well, can you afford to hire your own attorney?
I had an attorney, but I got to get in contact with him.
No, but can you afford to hire an attorney right now? Do you have the money to go out and pay maybe $500-600 for an attorney?
I'm gonna say not right now.
Well, I have a free attorney in the courtroom. He's a special public defender. Would you like me to?
I specialize in sleeping.
What?
I specialize in sleeping.
Yeah.
That and drinking Steel Reserve.
But he's I call him a special public defender. He's not the public defender's office from the state, but he's a free attorney. He can help you out in this hearing. Would you like me to just assign him to you?
Yeah, yes, sir.
Okay, so I'm going to appoint Mr. Shate. Mr. Shate, I don't. If you'd like, I just offer him a withheld adjudication. Wrap it up right now.
That's fine, Judge.
Your attorney agrees it's a good resolution. If you plead no contest or guilty, case is over with, wrapped up, you don't come back to court, it's over. You want to do that?
Sir.
How do you plead, sir?
No contest.
I'm going to withhold adjudication. Good luck. Thank you.
That's it. Is that it, Judge? I think it's just that one.
Good luck.
We're done. Thank you.
Perfect. Take care.
Kane McFarquhar.
I think he bonded, Judge. Let me check. He sure did. Victor, come on.
You see Victor Gonzalez, David Martinez, Josiah Graham, Michael Parrish.
Mr. Gonzalez, Judge.
Mr. Gonzalez, possession of a controlled substance without a prescription. Quick funds, probable cause. We have,
Yeah, he has an open PVP case that's not filed, Your Honor, from July.
sir, you have an open drug case PVP from this summer. I'm going to go ahead and set your bond today at $1,000. Thank you. How about David Martinez?
North Broward, Judge. Martinez is a medical reset, Your Honor.
Okay. Friday PM. Okay, Josiah Graham.
Main jail.
Count 8 is a warrant. Count 9 is a warrant for grand theft. Count 8 is not in custody, KPS. Just give me a moment here. I need to.
That's not.
Where is Josiah Graham?
Where?
There you go. Okay, sorry, I had it mixed up there. I didn't read this, but it'll take me just a moment. Let me look. This defendant acted as a lookout while a co-defendant entered the rear screen patio of the victim's residence, removed a bicycle. Yes. Okay. Defendant gave a statement, agreed to show detective location where he and his co-defendant committed the unlawful act. Defendant.
Okay, all right.
Okay, so court's going to find probable cause on each one of these. So I'm going to go ahead and give you a bond of $1,000 on count 8. Count 9 will be $1,000. Thank you, sir.
Thank you, Judge.
How about Michael Parrish?
Right here, sir. North Broward,
I'm for a mental health screening. I did have an opportunity to talk to him. He's been going through a lot. While he was in custody, his mother passed away.
All right. Sir, burglary of a dwelling. Court finds there is.
It's a change in charge. It went from occupied to unoccupied.
Okay. What was the original bond on this?
I think it was.
I think it's $2,500.
$2,500.
Okay, I'm going to put your bond back at $2,500, sir. Thank you.
Mental health screen,
I'm going to order a
Judge.
mental health screen. Thank you.
One second. We're live.
Charles Newton. Where's Charles Newton? Mr. Newton, Mr. Newton, I'll give you a choice today. You've been charged with a battery and a felony battery. I sent a text to your attorney. I don't know if he's going to get back to me. I don't know if he's in town or out of town. Would you like me to reset this case for tomorrow afternoon, and then we can see if your attorney is in town, he's gonna come to court, and then we can go from there. I mean, if not, I can go without your attorney, but I'm not sure that's a good idea, but I'll leave it up to you. Would you like to have a hearing right now without your attorney, or would you like
Could I
me?
get a bond? If you have a hearing now, you're gonna get a bond.
Right.
I need a bond, sir.
Yeah, but what I'm saying is, if you go right now, you're not gonna have your attorney arguing your case with you. You're going on your own. Or I can wait for tomorrow and your lawyer can make a presentation to me, maybe a lower bond, maybe some type of alternative release, I don't know.
Well, sir, I have to work in the morning. I have kids to support.
Okay, let me ask you this. Okay, you're charged with battery and felony battery. You want to proceed right now without your attorney? I'm not trying to scare you. I'm trying to just inform you that you have alternatives. If you want me to proceed, I'm not going to hold it against you if your attorney's not here. I'm just saying, you know, a lot of people want their attorney standing next to them. But, you know, I can go without the attorney. I'm not going to treat you any worse or, you know.
Yes, I need a bond, sir.
Okay.
I need to get.
Okay, so I'll go ahead and I'll proceed now. Sir, you're charged with domestic battery, I mean not domestic, simple battery 1, felony battery causing great bodily harm on 2. Court finds probable cause. Does this defendant have any criminal?
1996 battery. 2001 aggravated battery. 2003 a weapon.
2003?
Yes, Your Honor. The last 3 counts I gave were all with rules, just for the record. 2004 DUI adjudication. 2005 another DUI. 2006 driving with a suspended license. 2008 an arrest for DUI. Seemingly it was reduced to reckless driving. And he was adjudicated on a refusal. 2011 disorderly conduct. End of record.
Okay. Sir, are you currently employed? You say you are. What type of work do you do?
All right, I just got a job doing flooring with my friend guys.
Okay, do you have any money in the bank?
No, sir, not right now at this time.
No, okay, and, do you own your own home?
No, sir.
Do you have any financial resources to bond out of jail?
Yes, sir.
How much approximately do you think you could put your hands on?
When I came in my possession, I had like 1,500.
Let me ask you this, do you have family down here in South Florida?
Yes, sir. I've been here all my life.
Okay, do you have children?
I have 7, sir.
Okay, I'm just gonna read the highlight here, just to make a record. Said the Fort Lauderdale police responded to a possible hit and run involving a pedestrian, 13th Court in Fort Lauderdale. Allegedly, the defendant hit the alleged victim. Her name is Dancielise Allison. Allegedly hit her with a closed fist, knocked her to the ground. The defendant entered a vehicle and intentionally struck the victim with his vehicle, knocking her to the ground again. Then the defendant allegedly turned the vehicle directly toward the victim, Allison, and ran over her legs. The victim was dragged by the defendant's vehicle for about 10 feet, causing serious bodily injury and permanent disfigurement. She was taken to Broward General Hospital as a trauma alert. It says that she gave a statement. There were multiple independent witnesses who allegedly saw this occur, and defendant fled the scene prior to the police arriving. Defendant was positively identified on the scene by witnesses. So, okay. So, sir, you have a history of violent acts, battery, aggravated battery. Then you have driving issues, DUIs, reckless driving. So, to tell you, this is a very, very serious matter. I'm going to do this. You're going to have to miss work tomorrow. I'm going to go ahead and I'm going to reset this and let Mr. Rodman come in. I think that's in your best interest. You're going to have to call and tell him you're not going to make work tomorrow, all right? So this is Glenn
All right.
Rodman.
Do I have his number? I don't have his number.
I've got it. Well,
Okay. I do have it.
You have it?
No, I don't have it, Judge. If you want to give it to me, I'll give it to him.
could you call my number
Yes,
here?
sir. Your mic. Your mic. Sanchez.
Serafin
That?
Santos.
Is that right? Yes? Okay. I'll go.
Count one's an
Main jail
attempt.
judge, step forward, please.
I think count one's attempted, am I correct?
Yes.
Right, attempt.
Yes.
Count one's attempted premeditated murder. She says murder, but
Judge, at this time, I'm not moving for an Arthur hearing or making any arguments as to probable cause. I've read but I would ask the court to defer any findings of proof, evident, presumption, great, and let the division judge handle it.
understand. Ma'am, the defense been charged with attempted premeditated murder, count one, robbery with firearm, count two, count three, carrying concealed firearm, count 4, 5, and 6 are probation violations. Ma'am, are you seeking to hold the defendant without bond today on count one?
Yes, Judge.
1 and 2? They're both first-degree PBLs. Attempted murder, I do see that Judge Shear has signed the arrest warrant, and I see that, okay, 2 arrest warrants. She signed also the, let me look here. Signed and reviewed the affidavit. The court has read the affidavit from the Fort Lauderdale Police Department. It's prepared by Michael Benson. And let me just look here. Allegedly, this defendant on September 15th of 2015 on Sunrise Boulevard in Fort Lauderdale was at a Shop and Save Mini Mart, and he allegedly shot another man, Xavier Martin, in the head. There was an entry and exit wound to the base of his neck, and he gave a sworn statement that the shooter was this defendant, and he'd known him since middle school, and that it was a part of a robbery that he told him to empty his pockets. When the man turned to walk away, he heard gunshots, his body locked up, he fell to the ground, able to get to his feet, walked into a mini-mart where he asked for help. Police were contacted. He positively identified the defendant. So the court today is going to find proof, evident, presumption great, sir, that you attempted to murder this gentleman. I'm going to order today that you have no contact, directly or indirectly, with Xavier Martin. You'll be held without bond on count 1. Count 2, it will be no bond. It's set at $50,000. That's actually no bond. On count 1 and 2, count 3, $10,000. You'll be held without bond on 4, 5, and 6. Those are probation violations. Thank you, sir.
Judge, I don't want to, almost a difference without a distinction, but I didn't hear anything about the court saying anything about the firearm being concealed or any evidence of concealment.
No, he's charged with robbery with a firearm because he allegedly went up to the guy and pulled the gun, and when the guy wouldn't give him the money, he literally shot him in the neck. So,
Well, like I said, it's almost like a moot point. However, I didn't hear any evidence of a concealed firearm, any evidence of concealment, and I would argue there's no probable cause for count 3.
Hold on. Let me look. I thought you were talking about count 2. Count 3. You know, you're right. There's nothing about it being concealed. I'm going to release him on his own. Well, you know what? Why don't I give him a $100 bond on that so he'll get credit for it, all right? Okay. Count 3. I'm going to make it $100, even though I agree that there's probably no PC.
Judge, I'm not sure why, but it's somehow important to my client that it not be on there. If there's no probable cause, I would just ask the court to find no PC.
I'll do that, but you wouldn't get credit for the days you're in on that charge, but I'll do it.
Thank you, Judge.
I'll release him all I want on count 3.
It was a mess. Okay, thank you.
There you go. Okay. Okay. Now,
Thank you for that, Judge. We have 3 over here at the main for second looks. Do you want them?
yes, sir. Who do you have?
Luke Carmichael here, very anxious to resolve this trespassing.
Tell him
if he can.
Palm Beach County.
And he's saying he's moving to Palm Beach County.
Mr. Luke Carmichael, sir, you're here for trespassing. Let me pull up your case real quick. Down here. Multiple warnings, arrest at the property. And then somewhere in Pompano, they say you keep going back to the same place. We're on multiple occasions. I think that, I'm not sure where that is, but. Okay, Mr. Carmichael, if you want to plead out today, we'll take a plea. If you go back there, you'll just probably get rearrested, all right?
Yes, sir. Yes, sir.
All right, so what is the place?
It's a restaurant that my stepfather used to own, and he got rid of it and he sold it. So we're cleaning up the back of it. We're cleaning up like around the bushes and around the woods and stuff like that.
Okay, well